І запропонувати слово для виступу судді Європейського суду з прав людини від Ліхтенштейну Карлу Ранзоні з темою позбавлення волі в контексті статті 5 параграфу 1 Е та Ф Конвенції про захист прав людини і основоположних свобод. А далі будемо йти по графіку. Будь ласка.
Ladies and gentlemen, dear colleagues, thank you very much, Mr. President, for the invitation to this conference. It's a pleasure and an honor to be here. I would like to talk about the main requirements of the European Convention on Human Rights and of our case law on two specific aspects of the right to liberty and security enshrined in Article 5 of the Convention. First, the lawful detention of medical or social reasons, in particular of persons of unsound mind and alcoholics. It's Article 5, paragraph 1e. And second, the lawful detention of foreigners, in particular of persons with a view to their deportation or extradition. That's Article 5, paragraph 1f of the Convention. The key purpose of Article 5 of the Convention, as you all know, is to prevent arbitrary and unjustified deprivations of liberty. In this respect, the main issues that can be identified from the court's case law are the following. The emphasis on the lawfulness of the detention, the exhaustive nature of the exceptions in Article 5(1), the importance of the promptness of the judicial controls, and the necessity of sufficient reasoning in judicial decisions authorizing detention. Moreover, the court has held on many occasions that the detention of an individual is such a serious measure that it is only justified where other, less severe measures have been considered and found to be insufficient to safeguard the individual or public interests. First, to the detention of persons of unsound mind. Three main conditions must be fulfilled in order to deprive a person of his or her liberty on this ground. These are the so-called Winterwerp criteria stemming from our judgment Winterwerp versus the Netherlands. First, the person must reliably be shown to be of unsound mind. Second, the mental disorder must be of a kind or degree warranting compulsory confinement. And three, the validity of the continued confinement depends upon the persistence of such a disorder. To the first condition, unsound mind. What does that mean? There is no clear-cut answer to that, as the term does not lend itself to precise definition, since psychiatry is an evolving field both medically and in social attitudes. Detention is not permitted simply because the person's views or behavior deviate from the norms prevailing in a particular society. Unsound mind means a true mental disorder that must be so serious as to necessitate treatment in a hospital, in a clinic, or in another appropriate institution. Furthermore, the true mental disorder must be established before a competent authority on the basis of objective medical expertise. In the case of Zaichenko versus Ukraine, number 2 from 2015, the court considered that a prior examination by a psychiatrist, which had not taken place, would have been indispensable, in particular because there was no emergency situation. Another problem was identified in the case of Anatoly Rudenko versus Ukraine from 2014. The court there emphasized the domestic court's duty to scrutinize the psychiatric reports with the requisite diligence and to provide adequate reasoning for their decisions. It noted that such a scrutiny requirement was also included in a resolution of the Plenary Supreme Court of Ukraine from 2005. However, in the concrete case, the domestic courts did not undertake any critical assessment And apart from that, no independent expert opinion was sought. The second winter work condition, the mental disorder must be of a kind or degree warranting compulsory confinement. Such confinement must be necessary where a person needs therapy, medication, or other clinical treatment to cure or alleviate his condition, and where the person needs control and supervision to prevent him, for example, from causing harm to himself or to other persons. And the third condition, the validity of continued confinement, depends on the persistence of such a disorder, or to put it simply, detention should only last as long as absolutely necessary. In this context, I could mention the case of M versus Ukraine from 2012, where the domestic courts did not examine other, less severe measures that might have been sufficient for the protection of the applicants and the public interest. After the winter work judgment, a fourth condition was added. There must be some kind of relationship between the ground of permitted deprivation of liberty relied on and the place and conditions of detention. In principle, the detention of a person as a mental health patient will only be lawful for the purpose of Article 5 if effected in a hospital, clinic, or other appropriate institution. Such people cannot be held in a prison where the treatment and therapy required is unavailable. In this context, I would like to refer to Article 5, paragraph 4 of the Convention, which requires, inter alia, that a person's release shall be ordered if the detention is not lawful. Based on this provision, in cases where detention of mentally ill persons is potentially indefinite, periodical reviews in the light of the mentioned criteria must be taken by a judicial authority. If a mentally ill detainee lacks the capacity to initiate review proceedings himself, an effective regulatory framework to review is necessary to ensure such proceedings at reasonable intervals in order to determine the lawfulness of the continued deprivation of liberty. Detention of alcoholics, Article 5, paragraph 1e. As with other terms describing vulnerable groups in this provision, the term alcoholic carries an autonomous convention meaning. In this regard, the court, in its case law, stated the following: the object and purpose of Article 5, paragraph 1e cannot be interpreted as only allowing the detention of alcoholics in the limited sense of a person in a clinical state of alcoholism. Persons who are not medically diagnosed as alcoholics, but whose conduct and behavior under the influence of alcohol pose a threat to public or to themselves, can be taken into custody for the protection of the public or their own interests, such as their health or personal safety. It does not, however, permit the detention of an individual merely because of his alcohol intake. And in order to protect the individual from arbitrariness, the detention of an alcoholic in the meaning of Article 5 must not only be executed in accordance with the procedure prescribed by law, but it must also be necessary in the circumstances. In particular, domestic authorities need to assess whether the person behaved under the influence of alcohol in such a way that he really posed a threat to the public or himself, or that his own health, well-being, or personal safety were endangered. In the only specific Ukrainian case I found, Gukovic versus Ukraine from last year, the court concluded that the applicant's confinement in a sobering up center was neither based on accessible and foreseeable legal provisions, nor did the case file materials provide sufficient evidence that his detention was necessary in the circumstances. Detention of persons with a view to their deportation or extradition, Article 5, paragraph 1F of the Convention. This provision does not demand that this detention be reasonably considered necessary, for example, to prevent the individual from committing an offense or from fleeing. Article 5.1F provides a different level of protection. All that is required is that action is being taken with a view to deportation or extradition. It is therefore immaterial whether the underlying decision to expel or extradite can be justified under national or convention law. These principles were summarized inter alia in the judgment Soldatenko versus Ukraine from 2008. And in this case, the court also reiterated that the lawfulness of the detention must be examined with particular reference to the safeguards provided by the national system in order to protect the individual from arbitrariness. Legal certainty is a key element which also relates to the quality of the law. That implies that national law authorizing deprivation of liberty must be sufficiently accessible, precise, and foreseeable in its application. These requirements were not fulfilled in the Soldatenko case. In order not to be arbitrary, detention under Article 5.1F must also meet the following requirements. First, it must be carried out in good faith, in particular detention with a view to expulsion should not be punitive in nature. Second, the deprivation of liberty must be closely connected to the ground of detention relied on by the authorities. Third, the place and conditions of detention should be appropriate. And fourth, the length of the detention should not exceed that reasonably required for the purpose pursued. The court found that the responsible state did not act with due diligence, for example, in the following circumstances. In Mykolenko versus Estonia, the applicant could not be returned to Algeria due to a lack of documents and his unwillingness to cooperate. However, the state did not pursue the matter vigorously or did not negotiate with the Algerian authorities. In the case Joekale Vanje versus Belgium, the applicant's living address was known. She had always complied with the requirements, had tried to regularize her situation, and her state of health had deteriorated. However, the authorities did not envisage a less severe measure. In Kashmiri versus Turkey number 2, our court had imposed an interim measure under Rule 39. However, the domestic authorities prolonged the applicant's detention without taking any steps to find an alternative solution. And in this case, the court found a violation of Article 5, paragraph 1 also on another aspect. The applicant's return to his country of origin was found to be in violation of Article 3 of the Convention. Nevertheless, the state, although the applicant could be sent to a different country, did not take any steps in this regard. And finally, in AB and others versus France from last year, the applicants were placed in an administrative detention with their son, then aged 4. And the court noted that the presence of a child in administrative detention was in conformity with Article 5, paragraph 1, only as a measure of last resort, when the domestic authorities had verified that no alternative was available. But this was not the case here. I can skip a judgment mentioned already by Judge Jutkivska, the judgment Ilyas and Ahmed versus Hungary, I think 2 or 3 weeks ago, concerning the holding of migrants in a transit zone of an airport, which amounted to deprivation of liberty in a transit, in the meaning of Article 5. Finally, I would like to mention some more Ukrainian cases to give you a short overview. In several cases, the court has found violations where the applicant was detained despite the existence of established circumstances which prevented extradition or expulsion under domestic law. See, for example, the cases Garkavi versus Ukraine, Dubovik versus Ukraine from 2010 and 2009, respectively. In contrast, the court in Mokalal versus Ukraine from 2011 held that if the authorities' intention were to extradite a person, and if there was no legal or factual impediment to ultimate extradition, the detention could not be considered unlawful or arbitrary. However, in this case, a violation of Article 5, paragraph 1, was found on another aspect. The extradition request was withdrawn, but the domestic prosecutor authorized the applicant's release only 2 days later, and the court declared that administrative formalities connected with the release could not justify such a delay. In Molochko versus Ukraine from 2012, the court noted, in finding a violation of Article 5, paragraph 1, that the applicant's extradition proceedings were not actively and diligently pursued. Moreover, it reiterated in this context that an interim measure under the court's Rule 39, preventing the applicant's extradition or deportation, would not in itself form a basis for the person's continued detention. Komulo versus Ukraine from 2014. In this case, for the Ukrainian authorities, it was clear from the outset that the request for the applicant's extradition could not be granted. Nevertheless, the applicant remained in detention until the requesting state had lodged an updated request 4 months later. The court observed that Ukrainian authorities had not acted with due diligence and found a violation of Article 5, paragraph 1. Finally, in the most recent case of Kamorov and others versus Ukraine from last year, the court accepted that Ukrainian authorities in the first period acted with due diligence, but that was not the case in a second period. The prosecutor's report showed that the failure of the requesting state to provide sufficient information about the suspicions against the applicants constituted an obstacle to their extradition. However, Ukrainian authorities did not follow up on that conclusion and took no steps to request additional information, with the applicants remaining in detention for more than a year. This led to a finding of a violation of Article 5, paragraph 1. Furthermore, the court clarified that although at the same time various procedures relating to the applicant's asylum requests were pending, this could not for itself justify their detention. I hope I could give you a short review, a useful review of our court's case law on deprivation of liberty under Article 5, 1E and 1F of the European Convention on Human Rights. Thank you very much.